Welcome, Planet Green Trees, episode 166. I'm your host, Michael Komorn. Today is officially September 29th, 2013. The call number is 1-347-326-9626. This, of course, is Michigan's premier blog talk radio show.
We have launched.
Oh, I'm sorry. We went right over that. I'm in the groove. Leave me alone. I'm rolling with it. We're calling tonight's episode Free Bree. And nothing happy about that. We're going to talk about that. We've got a lot of concerns, and we're going to investigate what is exactly going on in the state of Michigan. Is it really as insane as it appears? What should other patients and caregivers take away from this? And why is this happening? And what's wrong with the Michigan Medical Marijuana? We're going to talk about all that. With me in the studio to bring you the most outstanding entertainment and information, Chad from the Birmingham Compassion Club.
Good evening. It's nice to be here.
Also, Rick Thompson, Compassion Chronicles editor-in-chief, and bringing the news a little bit later.
Hello, everybody.
Of course, our producer, well-renowned advocate, activist, and in the know, bringing us the most pertinent guests week after week, Jamie Lowell, Third Coast Compassion Center.
Hello.
All right, so tonight, as many of us in the community have heard and watched in horror, there's been a consistent issue going on with the Child Protective Services in Michigan that are where we're seeing the disregard of the protections created by the Michigan Medical Marijuana Act. One of the most recent and egregious examples of this disconnect with the law by CPS, Child Protective Services, concerns the Green family of Lansing. Many of you know Steve Green. He's a regular contributor to the show and is the local, I would say, head of the Cannabis Crusaders, Human Solutions, and goes from court to court and reports every week for us what kind of cases are going on. As many of you know, he's involved in a battle out in Oakland County that's been very, very challenging. He's got an unsympathetic judge, and they've revoked his ability to utilize cannabis, and he's a patient who's had some very, very serious medical conditions and has found cannabis to be the exclusive method to treat his seizures. And on top of all that, and fighting all that, and moving out of Oakland County, and understandably moving to Lansing, they just recently had their 6-month-old baby, Brielle, removed from the home because a judge found that the legally protected garden in the house creates an unsafe environment for the children because it may cause or be possible or bring about robberies within the house. The action by the state created massive stir with the medical marijuana and marijuana reform community, of which the Greens are very prominent, brought concerns on the state and national level as the question our system. Public at large was asking questions, how could this happen? There was civil protests and press conferences in Lansing on Tuesday led by our good friend Charmie, Gholson. And without question, the event and the gathering exposed some of these abuses and made it very apparent that there's some injustice that's taking place. The press conference was spearheaded by, of course, organization started in Michigan by Charmie, the Michigan Moms United. And, of course, joining us tonight will be the Greens, attorney Joshua Covert of Nichols Law Firm in Lansing, Charmie Gholson, the Michigan Moms United founder and the person that really tackled this issue and organized a very, very effective, I thought, media campaign exposing exactly what was happening. Of course, Steve Green will join us as well. And Steve does, as I mentioned earlier, join us regularly on behalf of the Michigan chapter of the Human Solutions to offer upcoming court dates and defendants who are in need of support. But tonight, unfortunately, he's going to be joining us on a different issue, which is how the CPS action has devastated his family. Additional contribution from Rick Thompson of the Compassion Chronicles and Jamie Lowell of the Third Coast Compassion Center, Chad, Birmingham Compassion Center Club, sponsored by Komorn Law, 1-800-656.
Welcome to the club.
3557. 1-800-656-3557. I want to thank the Michigan Medical Marijuana Association, all the moderators and administrators that helped to create a safe environment for the patient caregiver community, involved the conversation about medical cannabis. Give a shout out to our good friend in Ostamo, Michigan, Kevin Spitler, running up the Ohio decriminalization campaign. Also, a shout out to our good friend, the Marijuana Rancher. And, of course, those of you that know the Rancher, he heads up the Cannabis Cultural Center in Detroit. You can call him, make an appointment, 313-422-5281. And I want to say hello to our good friend, Dr. Komorn of the Green Light Clinic, 248-390-0574. And as I engage all day preparing for a hearing tomorrow where we plan to, not by choice, by circumstance, where we will not be able to call any doctors because they're not participating, I can say with absolute certainty that Dr. Kumar is a doctor that will come to court and testify for you. And in preparing on a case recently, I can tell you he was more thorough than most lawyers that I talked to, and I know that he's practicing certifying patients under the same guise. So I suggest if you're looking to be able to defend yourself, you look for a doctor who's complying with the terms and amendments of the Michigan Medical Marijuana Act as of April 2013. You should be expecting follow-up appointments. You should be expected to communicate with the doctor beyond just the day of certification. I remind everybody that the certification process is now a 2-year period of time that your card is valid. And if you think that the old way of doing it, of seeing your doctor and coming back a year later as it used to be, or now 2 years later, is going to provide you a Section 8 defense, I suggest it may not, and it may cause you problems depending on what jurisdiction you are in. If you want to defend yourself and prepare yourself for the worst and act in Section 4 compliance, but just in case you need to, you got to go to a doctor such as I mentioned, Dr. Komorn of the Green Light Clinic, and there are many others. I reference our good friend Dr. Bob Townsend, as well as Dr. Crocker out of the Grand Rapids area. I know all participating physicians, I would say, are thoroughly adapted to the regulations that have been fostered by the Department of Community Health and LARA, as well as the amendments to the Act. So that's what the show is going to be all about. I want to do a quick rant, and then we're going to get right on into it. All right, so I'm going to do a little, this incident with the Greens is awful, and it kind of exemplifies many, many of the failed implementations of the Michigan Medical Marijuana Act. While all of the change that's taking place nationally, the paradigm is clearly shifting. We have some significant resistance in the state of Michigan. We've seen it time and time again from the Court of Appeals, who seems to be out on a path to destroy the act. I remind many of you that but for the unanimous opinion by the Michigan Supreme Court, who have never really agreed on much in the King-Kalanick case, the first case to go to the Supreme Court, there was 19 Court of Appeals opinions that said ultimately that finding in favor of police and prosecutors that concluded that there was no medical marijuana defense. People would be precluded from arguing medical marijuana to a jury when that was the whole intent, their whole mens rea, the mind, what their thoughts were, and what it was directed towards, and to deprive someone. So you have to understand that the whole concept of how this act was intended, and I still think it wasn't intended, has been tarnished from the beginning. And I think a lot of those cases in the direction that it took the act, I think Justice O'Connell's opinion to the dark zone of interpretation, really set the act back. And what was resurrected from those opinions is what we're left with. And there's been a consistent theme, and it's an unfortunate consistent theme. And I said it before, I'm going to say it again, that the failures of what has taken place with the implementation is that there are no real protections on the Section 4 side, that all of your protections come after you've been arrested. The explanation of medical use cannot be done in the interaction with the officer. The fact that your door that may not be locked by viewing of the police officer and his determination is going to result in an arrest where you're going to have to defend yourself, where that issue is irrelevant. Seems very, very silly to see it over and over and over again. People have expected the act to work for them in protecting them from arrest. People don't get their cards so they can defend themselves in court. They get their cards so that they can present it in an encounter with law enforcement, and they expect it to allow them to get out of the police encounter positively. And that hasn't happened. It has happened in many, many situations. And further, despite the absolute clear reading of the language of the Act, in so many parts of it, it is not really facilitating that way. There's a language that patients should not be subject to lesser licensings in business or other rights that would be affected by that an individual would have not to be deprived of because of their medical marijuana status. The card is not to serve as probable cause to search. That despite these clear assertions and rights that are afforded a patient who's in compliance with the Act, we've seen people get fired from their jobs, employment not being protected. We've seen people get thrown out of their housing, federal housing, state housing, because they're medical marijuana patients. But it goes beyond that. It goes on to this other very, very strange expectation I talked about a little bit last week, but it relates to the outdoor growing of marijuana, or even inside the house, that for some reason this structure that's to be built around your grow must keep out a robber or a home invader or a thief or someone who's going to trespass and reach in and take. And for some reason, only in medical marijuana growing, indoor or outdoor, is this something that an individual would be responsible for. The idea that you're going to be responsible for preventing a crime upon you in advance, and to have it be foreseeable. And if it is foreseeable that you could be a victim of the crime, that therefore subjects you to arrest. It is an insane logic, and one that I think has been used in the case about the Greens, and I want to discuss that. The underlying principles we understand that resulted in the removal of the child was that the lifestyle or the decisions that were being made by the Greens would subject the family to possibly being robbed. And again, we're back to this idea that only because they're medical marijuana patients, they somehow have to foresee that they're going to get robbed and for some reason have to protect against it, or they're going to be viewed differently because they didn't take steps to protect against a crime that they have no idea about. What is it that Tom Cruise movie, the Future, someone saw it.
Oh, yeah.
But anyways, like being able to see a crime in the future. But anyways, the point is this.
Pre-crime.
Right, the pre-crime. The point is that there's some clear language that this Act states it can't be read any other way. There are protections afforded to people that are acting in compliance, and people who are caregivers or patients are not, under any circumstances, supposed to lose their children ever. And this is something that is unacceptable. And I'm going to quote Charmie, I think, who, very political, timely in referencing the Obama administration with the chemical weapons in Syria, that this is our line in the sand, that there's no exceptions to this, and that will not be tolerated under any circumstances, and that if this can happen to one person, it can happen to anybody, and we're not going to allow it. I remember watching the interview with the CPS spokesperson that said it had something to do with the decisions and choices that the parents make, and if what's being suggested by this policy by the Child Protective Services is that the decision to use medical cannabis is going to subject individuals to losing their children, that is not what this law was intended for. Now, I know that we're going to have the lawyers on for the Greens. The Greens are going to come out. We're going to have some more background about it. But I will tell you right now that this is outrageous, and there's legal action beyond just the remedies that may be available in court that should be taken if this is the direction that this law is going. Because if it's going to be a walking all over and destroying the Greens, it's not going to stop. People have to be aware of it. There's a lack of understanding that this law was intended to protect. It's a prophylactic law, not to be used as a reason to arrest people. It's a big difference. This is about public health. It's not about public safety. And when you bring children into, we all have a vested interest in making sure that children are protected. That's what CPS is supposed to do. They're supposed to make certain that the house that the children are living in is habitable for the children, that there's no danger or risk that's involved because of the house or lack of contents therein. There's a list of 12 or 13 factors that a court will consider when assessing a removal or changing of custody. And if they're focusing on a decision to be a caregiver, which is out of necessity. We know the Greens. We know Steve is very ill, and this is the only medicine that works for him. So we've got some real issues here. I think also it's a important time of this to exasperate and bring to the national media the discussion about the children and how it is wrongly being interpreted and how it's wrongly being abused in negative ways. That the idea that children may be around cannabis because of medical reasons, assuming that the parents are locking and closing, children don't have access to it, should not be an issue. There should not be a presumption that people are violating the law. Just the opposite. Get your card and your weights. We know there's a presumption that can be rebutted only by evidence, not bad thoughts, that there's non-medical use of the cannabis at issue. So we're at an important point, I think, in this, and the topic of the children and cannabis is always very, very challenging. Something that's used as a propaganda piece. And I think that's what's happening here as well. But I know that the story as it's been written is very, very, shows the offensiveness of the way the state has acted. And it's a conversation that we're going to indulge into tonight with our guests. And that's my rant for right now. You are listening to Planet Green Trees. We're going to be back right after this.